Welcome to Speak Out. I'm Sandy Galef, a member of the New York State Assembly, representing parts of northern Westchester and parts of Putnam County. And today we're going to be talking about the courts, we're going to be talking about mediation and opportunities for people to resolve their problems in a very different way. And I think you're going to find it a very interesting discussion with two wonderful panelists here on the program. One is Justice J. Peter Collins, who is the Town of Kent Justice, and also an attorney at Feldman, Kleidman and Coffey, which is in Fishkill.
Yes.
So we welcome you very, very much.
Glad to be
And
here.
also Joyce Mitchell, who's an owner and mediator at DFFM Divorce, which stands for Family and Financial Mediation. And also, Joyce, you're a volunteer certified mediator, because you've always told me if I have some issues, with constituents and so on, that not personally with me, but that are having some problems. I guess it could be personally with me too. That you would be willing to help, and you do your work in Putnam County, I believe. So
most of it, yes. The volunteer work is all in Putnam County.
Right, but the other work you do is throughout the
Could
area.
be from New York City throughout the Hudson Valley.
Right, terrific. Okay, so Judge Collins, Peter, tell us all about mediation. What is this all about?
Well, in the justice courts, we have a civil jurisdiction up to $3,000. And I'm going to say perhaps maybe 5 or 6 times every month, I have civil matters. These are disputes between citizens. They're either disputes about money or they're summary proceedings. Actually, I probably have about 10 of them per month. Mm-hmm. And these are very time-consuming. We can be there to the wee hours of the morning litigating these civil actions. And about 4 or 5 years ago, we started to use Joyce Mitchell and other members of her staff as volunteers in our court to assist in mediating the disputes between citizens. And it has been a very, very successful program for the court. And I'm going to say that Joyce probably and her staff have mediated well over 90% of the disputes that we've had in the past 4 or 5 years. It's very beneficial to the court because it provides the citizens with a non-adversarial setting in which to address and, with Joyce and her colleagues, resolve these disputes in a manner which is acceptable to all parties, results in a stipulation of settlement, and saves the court a great deal of time and effort.
So when these cases come to you, do you sit and talk with the parties about potentially going to mediation? How do you interact there with the individuals?
Well, I invite them to participate in the mediation. I introduce Joyce to them. I tell them that it would be my preference that they sit down with Joyce beforehand to see whether or not the matter can be resolved without the necessity of a trial. I don't force it upon them. And if it doesn't resolve itself, then at the end of my calendar, my traffic calendar, then I start my civil calendar, and then I will preside over the disputes.
Do you find the attorneys that are representing them, do they have attorneys at that point?
50%.
Do, okay. Are the attorneys willing to suggest that to their clients, or is there more opposition from those that have attorneys versus those that don't?
No, I think the attorneys are more than willing to participate in the mediation process. And quite frankly, I can recall only 1 or 2 instances in the past 5 years where she has not been able to mediate the claims with the attorneys present.
Well, most of the attorneys are actually quite helpful. We have certain procedural rules. It's a voluntary procedure to begin with. So
You're all volunteers. Let's go over that again.
well, yes, my role in
Putnam County.
In terms of the Justice Court in the town of Canton, or
Right.
actually I work in the Justice Court of many of the towns in Putnam County. And that role is called community mediation. And it's administered by the Dispute Resolution Center. Now, the Dispute Resolution Center is a nonprofit, 501c3 actually, agency that is funded by the Unified Court System of the state of New York. So actually that comes through the legislature, that funding. And in that role, the cases that Peter referred to that are handled are limited generally to summary proceedings and claims up to $3,000. Sometimes they're represented by counsel, sometimes not. Because it's a mediation, what we want in that room is that for the parties who are in the conflict to speak, not their attorneys. And that's all right because the attorneys are still there and can go out of the room and give their clients counsel as well. But what we assure them of there is total confidentiality. Neither I nor any of the participants would be able to then go before the judge. If we failed to get a mediated agreement, would be able to go to the judge and say what it was that was said in that mediation session. He won't accept it as evidence. And that's the protection of privacy in there that is in confidentiality that's so important and empowers people to speak freely.
Right. So if a person has to go back to the judge, you really
All I
don't
know is
know
they-
what's happened.
I
You just
don't.
know it hasn't worked.
It hasn't resolved
That's right.
itself.
We just simply say we couldn't reach a mediated agreement, Your Honor, and bow out, and then that's when His Honor takes over and hears the case.
Now, before we instituted the mediation, when civil cases would come before me, I would, only with the consent of both parties, ask if they wanted me to attempt to try and resolve the case, in which case then I would take them into a conference room individually and speak to them. And it's a very, very fine line that you walk as a judge, because when you go in there and you listen to one side, then you listen to the other, they're not sworn. And you have to be extremely careful that you can put all of this out of your mind in the event that you're not able to resolve it, and then sit in judgment.
So that's very difficult. That
It
would be
is.
very difficult. Sounds like this is an easier program, because at least it's separated out. You don't know what's been said, and then you go back to
It's like having it all anew.
right.
And
right.
when we do reach an agreement in the mediation room, what we do is we write it up, then we go with the parties before the judge. The judge looks at it, he asks both of the parties if they do agree to the content, he reads it out, and if so, it becomes part of the file of that case.
Now, is that if they both signed? I'm assuming that's pretty binding, or
It is
or
binding.
not?
Oh no, it's binding.
It's binding.
And because I so order it at the end, and it's more than just reading. I explain what it means. Although it's been explained by Joyce, they all understand what has taken place.
But you ascertain that, and
Right.
so that's a double guarantee.
I put them under oath, and then ask them if they understand it, if they have voluntarily agreed to it, and is this something that they want to do? And as long as they say yes to all of those questions, then I so order the stipulation. Now, every stipulation has a provision that in the event of a default in the terms of the stipulation, that the plaintiff or the petitioner is not required to relitigate. That upon notification, written notification, given an opportunity to cure the default, and the failure to cure the default will result in the entry of a judgment against that party for the amount of the default. So
Let's do an example of that. And I want to go back to Joyce and say, how long does this all take? Is it over a night, or is it over weeks, the mediation?
Most
that you
of
might be
the
going through?
cases in community mediation, which is neighbor disputes, dog bites, can be evictions, things of that nature. A merchant trying to collect a bill, or somebody suing a merchant because they feel paid for services they didn't receive. And that usually I know within 20 minutes whether I'm going to get a mediation agreement or not by the level of animosity in the room. If I can get people to start talking to each other about what went wrong, usually we can reach a mediated agreement. I would say the average goes 30 minutes, but there are times I've kept the court open quite late and it's gone longer. I do have, however, and I've done
So it
this
doesn't necessarily go into several days.
No, but there are occasions, particularly with Judge Collins' court, where the matter ran so long and there were some unresolved issues, there was information they needed to get, that we made an appointment to meet at the dispute resolution offices another day. The court holds the case over, and then we finally notify them of the final agreement. So that's a possibility. It's not what's done usually, but it can be done.
So let's go back to, so there are two individuals in the community, and it's about money. Maybe it's I remember one time when my son ordered a waterbed, the time of the waterbeds, and he didn't get his product completed with the drawers underneath. So we actually went to small claims court.
Okay.
And so at the end of the day, we didn't have mediation. I think that was prior to this whole mediation. But I'm assuming that you could have had mediation with the purchaser of the product and the owner of the shop that was supposed to provide it. Would that be something that might come before the mediation?
We do those very frequently.
And so they've signed, and maybe they've agreed to split the difference or whatever they've agreed to, and they've signed it and it goes to you. And then somebody defaults, the owner of the store doesn't pay the client. The client has paid the whole thing and needs to get a refund. So would that be a...
Well, typically what would happen is there'd be installment payments. Let's say the claim was for $3,000, we split the difference at $1,500, they agree to that. The settlement is made a matter of record, it's reduced to writing, and it's also put on the court record. Each copy is given a copy, each party is given a copy of the stipulation. The person who is required to make the payment makes 5 $100 payments in accordance with the agreement, but then defaults. The other side would then have to send a letter to the party saying, you've made 5, you're in default. You have 3 business days or 5 business days to correct the default. If the default is not corrected, then with an affidavit and proof of notice of the default and proof of notice that the other party has been given notice, they can come back to court with paper and ask for the entry of a default judgment for the unpaid balance of the settlement, which would be, in this case, would be $1,000. And if that is not opposed by the other side, then I would enter a default judgment in the amount of $1,000 for the prevailing party. And that's how it would go.
That's how it works.
Yeah.
And let's go back to some of the other, I'm just trying to think, in my office, we get calls. We get calls on a lot of different things, shared driveways and community members not happy on one side or the other, from tenants. I don't know whether this comes in with maybe in just like a 2-family home and issues that arise, or smoking in apartments. I mean, I don't know whether this all ends up. Does it all end up in your court?
But
all the things that people call me that.
But the interesting thing to note is it doesn't have to end up in court.
Right.
So many of these cases that we mediate, they simply have to call the Dispute Resolution Center. Now, this Dispute Resolution Center goes under...
You're saying they could start with you.
Exactly. They don't have to go to court. And many of these are settled in the dispute resolution offices. We deal with community, we deal with post and pre-divorce issues having to do with the co-parenting of children, having to do with child support issues, having to do, they even handle divorces. So the range of almost any dispute can come. Where we draw the line in general, this is not always, but generally it's a practice, is where there is violence between the parties, where there's an order of protection, for instance. Also, I find it doesn't work to mediate with people who are addicted because they really can't keep their agreements. They have a master that drives them. But once there's rehab, of course, then it's fine.
So you're not taking them, Judge Collins, do you offer mediation to people like that, or do you find
Those
that?
are more criminal nature. Criminal matters, yeah.
right.
We don't mediate the criminal matters.
Right.
Those are negotiated, discussed, and ultimately a disposition is either agreed upon or there's a trial. But that's between the district attorney and either the legal aid or the private attorney.
But we don't have that now. Actually, some cities, New York City being an outstanding example, do something called restorative justice. And this is for first offenders, nonviolent, and they do use mediation practice in that. I've actually talked to some of the people in our criminal justice system about bringing it to Putnam. No one has said no yet. No one has said yes. There's a lot of research that needs to be done.
Right.
I can understand that in New York City. I'm not opposed to that. But I mean, after 13 years of observing the district attorney's office, legal aid, and the private attorneys, they take a very practical approach to those criminal matters. And the accused are well represented, and so are the people. And there are occasions when I may be able to tweak something, but they're very good at what they do. I, as an overseer, I guess, I have no complaints. I think they're very good at what they do.
Right. Now, you don't have divorce matters in your court, do you?
No.
Or do you get a tinge of it
No.
somehow? No.
I don't. That's
Right.
the Superior Court has jurisdiction over those
So,
matters.
but Joyce, through mediation, might be able
Yes.
to deal with people. Do you
Yes,
feel?
we do, and also we do. I also mediate issues that come out of family court, not just out of small
Right.
claims court.
Right. So let's go back to what are the type of issues that get into a local town court? I have a lot of towns in my district, and it might be a little different than the city. I don't know. We're sitting in the city of Peekskill right now, but with the towns, it's what kind of cases do you have that are brought before you generally?
There's town violations. That would be violations of the zoning ordinances. There's neighbor disputes. There's summary proceedings, which involves landlord and tenants. And then typical disputes, I bought this, I didn't get what I paid for, I want my money back. Or I
Right.
performed a service for an individual and I didn't get paid. Automobile accidents, property damage claims. Actually, I've had a few personal injury actions, but they're limited to $3,000 in terms of damages.
I've even had an attorney who
Yeah.
was suing a client for a bill
Non-payment?
unpaid,
Right.
legal
Right,
services unpaid.
right.
And then we have the non-criminal dispositions, the violations of the penal laws, which are not crimes, misdemeanors. And we do all of I shouldn't say we do all of the preliminary, but we have the jurisdiction to do all of the preliminary matters in felonies until the case has been presented to the grand jury. And once the grand jury indicts, then they take the jurisdiction from us and the case is transferred to the county court.
In the town of Kent, which is
Yes.
a very rural community, which may be different than some other communities, but what would you say are the most significant numbers of types of cases that you get?
Motor
Is there
vehicle.
motor vehicle?
Yes.
Motor vehicle.
Because we have 84 and part of the Taconic State Parkway runs through
Yes.
the town of Kent.
Right.
So,
right.
and I think Judge Dushkoff and I probably handle, I'm going to say maybe 6,000 motor vehicle cases a year.
Wow.
And then each probably handle 1,000, maybe 1,200 criminal matters per year. And then 10 civil matters per month. So 120,
Right.
that's 240 for the court.
Right.
It's a very active jurisdiction.
Right, right. And with the mediation, do most town justices, do you think, are they as willing and eager to try mediation as you are? Do you think that
I do.
you do?
I do.
Okay.
The civil matters are extremely time consuming. And as I said, and I mean that in all sincerity, so that if these matters are not mediated, and they're mediated while court is in session, but if they're not mediated, then at the end of that calendar, you have to address the civil matters. And if you have 5 on a night, these people expect that their cases are going to be heard and litigated that evening. And I know as a young lawyer, I spent many an evening in the justice court till 1, 2 in the morning, waiting my turn to litigate my case for my client. So having a mediator come and being as successful as Joyce has been.
Did you say she was, what was it, what percentage?
9
would you
out of
say?
10 at least.
9 out of 10.
Yeah.
Wow, I don't know.
Right.
And she's very diligent in what she does. She's very, very good. And I think the results speak for themselves. She's very successful.
Right, right.
I would say that all of them are mediators because there are a number of them. I'm not sure the complete number in Putnam County, but at least 10 that cover. And they're all, some are attorneys who no longer practice law. And also I think I should clarify that even if a mediator is an attorney, if they're mediating, they're not allowed to give legal advice. In other words, you
Right.
can't cross
So
as
who else would become a mediator? Would somebody, a social worker, or what would your background be that?
I would say people from mental health backgrounds, from law backgrounds.
Judges,
Judges.
Judges,
Okay.
yes.
Judges.
Supreme
Yes.
Court and County
Right.
Court judges serve as mediators for private firms.
Right, right.
And anyone who has any background in litigation. And I'm just talking about the field that I've practiced in, but attorneys who have tried cases, who are involved in litigation, are asked from time to time to mediate cases. You have to have the agreement, though, of both of the parties, or the attorneys, and they select the mediators in the
So that both parties have to say, I'm willing to try this.
oh, yes, yeah.
Oh,
They have
Before
to
you even
cooperate.
begin.
Yes.
Absolutely.
Before you begin.
If I take 2 parties into a room and one of them says, I don't want to mediate, all I do is take them back to the judge and say,
Yeah.
we were unable to reach an agreement, so that there's no prejudice against which party turned it down or anything like that.
Where does arbitration fit into? Does it fit into it?
Arbitration uses some of the same skills, but
Yes.
in arbitration, that's a decision. And when the people enter into arbitration, they agree that the judgment of the arbitrator will
Is
be
binding.
respected.
Is binding.
Yes.
But basically mediation, it's binding, but
It's mediation really is not.
no. Okay.
It becomes binding when you agree. When the mediator has a solution and you both agree to it and a record is made of it, then it's binding.
Right, right.
The arbitrator, the difference between arbitration is you'll go through the same process with the arbitrator, present your proof in an informal setting, and then the arbitrator makes a decision. And
So
that
you
decision,
haven't, right, you
right.
don't necessarily have agreed to it, but that's the decision.
with mediation, it's a threefold decision. The mediator agrees and both parties agree. So there's a consensus there. And that's what makes it, that's why we're able to put it on the record. and
We
make
all
it
sign
binding.
that agreement that becomes part of the court file.
Right. Let's talk a bit about the economics of all this. You referred to it a little bit in your opening, actually, about savings in the court. Let's just talk about that from that perspective, from the public dollar perspective, or the saving of time for the judicial system.
Well, there is some savings. The primary savings are time. The secondary savings are the support staff for the court who get paid on an hourly basis. So if court is going to go till 1 or 2 o'clock in the morning, these people are entitled to be compensated. That not only includes the clerk, but the
bailiffs,
security,
right.
the bailiffs, and the security personnel. I think there's also a savings to the parties, and that is it's not so much in the justice court, but overall mediation is less expensive for the parties than going through the litigation process from start to finish, which can be very costly.
Even if the mediation, I mean, Joyce does it as a volunteer, but you also do it in your own role with your business. But so even if, well, obviously as a volunteer, there's less cost, but also you're saying mediation just generally,
Yes.
even if you have to pay for it, it's really less costly.
There would be an agreed upon hourly rate for the mediator, but the process is so informal that, and it's more expeditious than discovery and litigation, than having your case being put on the calendar and paying all the fees associated with that, then waiting for your case to come up on the calendar, and then proceeding to trial. You know, if you decide to mediate, you just go right to the mediator. The decision is who will mediate, can we agree on that person, and then there's an agreement generally in private practice between the attorneys as to what will be presented to the mediator. And there's an exchange of documents, not as expensive as going through depositions, filing discovery demands and discovery responses. and
Which
not
are the
as
things that
time-consuming.
really stretch out a lawsuit, are all of the motions that are filed in deposition. In mediation, all of that is disposed of. You
So
don't
let's
need
talk
that.
about that, the human role. It can save money to the courts.
But it
can-
empowers people,
people,
you see.
okay.
And I always say, you in this room have the ability to decide, and you know more about your issues than that man sitting with the black robe on in the courtroom. And it is true. And once people engage in talking to each other, not in every case, but in many cases, once they're allowed to get out emotionally what really disturbs them, because a lot of these cases are far more about being heard than anything else. I mean, I've had some of the most passionate cases over $200. But once somebody is heard and knows that the person opposite them has heard them, something happens. It's a magic moment, and a lot of tension is relieved, and that's when you know that they are going to find some way to agree. And the agreement, if I described some of these agreements in terms of who paid whom what, you might find them to be unjust in terms of what would be decided in the court. But the people leave that room relieved. And I call it like each little drop in the cup of more peace in the world.
Right, it's great. Now, if people want information about mediation, where do they find this?
They go right to Joyce.
Okay,
Thank you.
Joyce?
No,
you have a
no, the Dispute Resolution Center, which is listed in the phone book, this Dispute Resolution Center for Putnam County is administered out of Orange County, actually. I think the organization administers Putnam, Orange, Ulster. I'm not sure if they do Rockland also.
Right.
Rockland
Okay.
may be another. But
All
throughout
right.
the state, there
Right.
are these, they
All right, we
all
have to stop.
Okay.
But just check out the Mediation Center, and hopefully this has been very valuable information to all of you. I know it's been valuable information to me, and I'd like to thank both Peter and Joyce for coming here tonight. If you have any questions, give me a call at 914-941-1111. Thank you very much.
Thank you.